Good evening and welcome to Truth and Justice TV. My name's Jennifer Obaseki, and today we are going to be talking about something that I think will affect quite a few of you who are here in the UK. Today we're going to be talking about the EU settlement scheme and what you need to do if you miss the 30th of July deadline. And today with me is my colleague and my good friend, Dr. Alex Amicarelli, who is an expert on EU law and hopefully will answer any of your questions around this particular topic. So, Alex, or
evening,
Dr.
Jennifer.
Amicarelli,
Alex is fine.
first of all, congratulations for winning the European Cup.
Yeah.
And thank you for
you.
celebrating with us in the office with a pizza party. But for those of people who are out there who may not know you, who are you?
Okay, good evening everyone. I'm an Italian lawyer. I first qualified in Italy, then I moved to the UK, made the UK my home. I qualified in the UK. I specialize in EU law, international law and everything international. So, as Jennifer said, there are a few things to talk about in respect of the EU settlement scheme. For those of you who are not aware of this scheme launched by the UK government back in 2019, it's basically a way that the UK government found in order to let people from the EEA countries to settle in the UK following the Brexit vote. So it's been a very specific scheme aimed at European citizens who live in the UK. The deadline was the 30th of June this year. There have been a number of campaigns in this country, on TV, on social media, but we are aware that many people
Still missed the deadline.
We received a number of calls on the very last day.
Up to the very day, I think we have submitted about 3 applications, even in the office.
Very last minute.
Very last minute.
Very last minute. And the problem is that the government, back in 2019, they expected some 3 million applications, but as of the end of May, the applications received were 6 million.
Double the amount they expected.
But what's the reason behind the success of this scheme? The reason is that the system is very generous, very flexible, and is not aimed only at EU citizens, but also at people from other countries such as Switzerland and other countries part of the EEA system.
Yeah, but for those people out there whom think, do you know what, I wasn't ready at the time, what can I do now? So I'm an EEA national, I'm here, I've been working, I just didn't get onto the app, or I didn't know what to do. What does that person do?
That person specifically, so the European citizen who is in the UK, was in the UK before the end of December last year, who was working or studying or anyway living in this country, even though they missed the application, they still have time to apply. The deadline was not extended. The Home Office clarified this point.
Yes, because there have been confusing information about
very
that.
Confusing information. And I can also say, from what we heard from clients, also the number of wrong information about the system as such was enormous.
Wow.
A lot of wrong information. The system as such is very good. It was very well organized, but not everyone is able to read the legal terms and everything.
So not reading legal terms, yes?
So the person who missed the deadline, who was working, was here before the end of December last year, can still apply. The government said there is no extension, but there is a kind of 28 days flexibility. So those of you who have not applied by the end of June should apply as soon as possible.
As soon as possible. All right.
The system will be in place for very long time because, as I said, it's very generous, and it is not only aimed at the individual who was in the UK before the end of December last year, but also at family members,
Okay, so
relatives, and so on.
for our majority viewers and for majority of like my clients, and I know those out there may have this number one question. So even if they were here and they have relatives who are in Africa or the Americas, so they're an EEA national, they were here, they managed to do their own application, but they have relatives that they normally send money to that rely on them, parents or cousins or people that they just lean on to support for school fees and accommodation. What can that person do for those relatives who are still in their own countries that are way outside the EU?
Yeah, as you said, we have a lot of clients who are Nigerian, Italian, or from other EU countries. So this very specific case happens every day to us to help people who need to bring relatives from African countries or from the Americas to the UK. In this case, if you were sending money regularly to your mom, to your dad, to your children, to your wife, to your husband, or
Cousins. We'll talk about direct, but then we have to talk about those extended family members.
Yes.
So first of all, direct family, children, parents.
Exactly. Okay, for children, it's quite easy for a parent to bring their own children to the UK. You must be submitting some evidence, of course, and you must also be able, at request of the Home Office, to show the original documents. For parents, it's slightly different. So it means that till the end of June, so till the deadline, you were able to bring your parents, so to submit the application for your parents without submitting any evidence of dependency. So there was no such need.
It was assumed your parent is your dependent.
Would depend on you. From the 1st of July, you have now to show evidence that your parents, dad or mom, depend on you. So one of the evidence can be showing evidence that you were sending money to them.
Money, paying rent, paying for carers. Okay, and can I just ask you, for children who are, let's say, adopted, or children that may belong to a relative who has passed away, that's not a direct biological child, but how would the Home Office view that type of situation?
Yes, again, the system is very welcoming, very, very flexible. So adopted children, if you have an adoption certificate, they will be allowed to apply. In case of a relative who passed away in the UK, there is a system called a retained right. So if the person was in the UK and passed away, you can also apply basing on the retained right of this relative who passed away. Wow. There are a number of different rules and scenarios, and
So please, what I'm going to do is take a very short break, and when we come back from that break, we're going to discuss these other rules and guidelines that are given to caseworkers and talk about those people who are not direct relatives, that may be extended family members. So see you just after this break. Thank you for staying with us. Now, just before the break, we spoke about some of the situations that people might find themselves in if they've missed the 30th of June deadline to apply for their settled status or to deal with relatives who they wanted to bring into the UK. So we were going to talk about those extended relatives and also some of the guidance that the scheme offers to people who might find themselves in unusual situations. So let's talk about the cousins, because the cousins and second cousins and compound relatives are something that Asian and African families tend to have for cultural reasons.
Yeah.
So let's talk about
And
those.
we can also say that also the
relatives.
Italian people tend to have.
Oh, godfathers and
Exactly.
god cousins and
Yeah,
cousins.
so it's very common to have. We had clients who wanted to bring cousins or second cousins to the UK. Basing on the settlement scheme system, bringing a cousin is not automatic. But the good thing is that every single case is assessed individually.
So it's all about the subjective
It's
evidence.
all about the subjective evidence, and the evidence is very important. So you need to provide as much evidence as possible. So birth certificates, marriage certificates, if there was no marriage, any other form of evidence that people were living together as husband and wife, or something like this, or if the cousin was living with in the family in the same address. I know that in some countries it's not very easy to get evidence, but you need to do your best to get the evidence you need.
So that could be witness statements, evidence from estate agents, and again, pictures are good, but they're not formal documents. So you're really looking for evidence that you resided in the home. So letters from schools and other even medical bills showing that you were residing in the same compound or home, to show that you're part of the family unit.
Yeah, the other important thing is that the fact that you don't have all the evidence at hand when you want to submit the application, that's not an issue, because as I said, the system is very flexible and welcoming as well. So you can still submit the application and then have time to put all the evidence together. So you can submit the application without evidence, and the evidence can be submitted afterwards. So you have even more time to build your evidence to submit and to support your case.
It's more flexible than people might think. But there was one thing you touched on before the break, and that was called the derivative rights. Now, many people don't realise that even if their relationship with an EEA person broke down, assuming your spouse was an EEA national, things have fallen apart, and you don't have evidence of the continued marriage, or you've left the home or they've left the home and you don't have the evidence to submit to the Home Office, or you're a child of a EEA national and you've come in as a dependent from abroad and your initial 5 years has expired, you've not been able to meet the 30th of June deadline, and you are no longer in good communication terms with that relative. What does that person do? Because we see that a lot as well.
Yes, we see that a lot, and the best thing is to, as you mentioned, all these ways to find evidence. Do your best to find any evidence. Go to your church. If you had any court cases in the country, go and try and trace
bills.
Any documentation.
Even bills.
Even bills. Any council tax letters. And most councils are very, very helpful. We know that now with COVID, the councils have reduced personnel. It's taken very long time to come back when you make any inquiries, but they are really very, very helpful. They are there to help. So if you can show some evidence that you were registered with the GP or something like that, they will be issuing a new letter stating that they know you were based at that address. The other important thing to say, this caused a lot of confusion in people, and I'm not surprised because yes, the system for us, we read the law every day, so we know how to interpret the regulation, but for the lay people it's not that easy to understand. So what's the difference between pre-settled status and settled status, and how much time I have, how much time is permitted to be abroad?
Oh.
Because you can get your pre-settled status, but you can also spend some time abroad once you have the pre-settled status. And the same applies when you have the settled status. So normally, the pre-settled status is given to anyone who has evidence that he or she was in the country before the end of December last year, providing some evidence,
Yes.
of course, as bills, bank statements,
But
and
you
so
had
on.
to be here,
But
and you
you
had
had
doing
to be
exercising
here.
security rights or studying.
Then, if you have been in the country for at least 5 years, and again you have the evidence of the continued residence in the country, which doesn't mean that you are not allowed to travel. Of course, you are allowed to travel. You can spend up to 6 months in a row abroad. That's not a problem for your 5 years continued residence. If you spend more than 6 months, there may be issues, but again, the Home Office is quite flexible, and if you can provide evidence to clarify why
You
you
were
spent more than 6 months
Uh-huh.
abroad, they will appreciate it, and hopefully the application will be successful. So, if you have the settled status, so after 5 years, at some point you can also apply to naturalize as a British citizen, if you want to do so. As a
If you
further,
want to have a second nationality.
if you want to,
and if your country allows you to pick up the
Exactly.
UK nationality, because some
Yeah.
don't allow having to.
some countries don't permit, the second nationality, but if you can do it, we
Yeah.
always advise.
We always advise that
yeah,
you do.
do it, because if you spend a lot of time in this country, you will start feeling at home. This is your new home, so it makes sense that you
Exactly.
become a citizen and you contribute to the life in this country, also by voting, not only by.
Yes, I wasn't even aware that even if, as a foreign national, you might not even be allowed to take judicial appointments in this country, which seems very harsh, especially so you could be an excellent lawyer, excellently contributing, but because of the lack of citizenship, you might be precluded from doing certain things within the society. So I tell you what, we're going to take another short break, and then just at the end, we're going to run through some common situations and also our contact details. So if you have questions that we've not answered for you, feel free to email info@obasekisolicitors.com, and then Alex will also leave his details after this short break. Thank you for staying with us. Now, we've been talking about EU nationals, what to do if you've missed the deadline, what to do if you've been here and you still want to bring relatives, what to do if your relatives are indirect extended relatives. And right now, I'm going to ask, what do we do if we've been refused? What do they do if they've been rejected, or there's been complications with their application, misinformation of some sort? What do they do?
Yes, basically the Home Office, when they assess your application, if there is any issue, they will first email you, then they
should
will
email.
call you. Normally they try emailing you 5 times and call you 5 times before rejecting any application. So again, the system is very, very open,
Flexible.
very flexible. They try and make their best not to refuse any application. So they may request further evidence, they may request better evidence, because at times people do screenshots of birth certificates
Okay.
that are of very bad quality. When they upload them onto the system, the quality is horrible and they can't even read it. So But at some point, some people maybe refuse the application because maybe they don't answer the phone because they suspect it may be a scammer calling.
Oh, that's
Yeah.
true. Nowadays, people are very apprehensive when you get
Yeah.
emails and you're not sure whether it's genuine. And also phone calls from people asking you for your personal details. They might be guarded. You might be guarded for giving them away. I am. I definitely don't give out information over the phone.
So you maybe rejected the application. So what to do when the application is rejected? When the application is rejected, you normally have 28 days to appeal it or to make a new application. The Home Office is very helpful when you have any issues with it, and most of the applications have been accepted.
Can I ask you something? With the
Yes.
application, there's no fee, and with the
Yes.
appeal, there should be no fee
fee
as
at
well.
all. Yeah.
So you have nothing to lose by putting
Yeah.
in the application or appealing. There's no fee attached.
Yeah.
But there are some solicitors who've been charging exorbitant fees, and there are some solicitors who've been very, very bad and putting more people on applications without the EEA person's knowledge. What do you do if you're an EEA national and you've been the victim of a bad solicitor?
Well, report the solicitor.
Yes.
Yeah, that's what has to be done because we want our profession to be as much
Respected.
respected
Yes.
and transparent as possible.
Exactly.
We have a very strict code of ethics. We have very specific rules. We are regulated in this country. We are a very old profession, and we cannot accept that this happens in the profession or even outside the profession, because we know there are a number of unregulated people that present themselves as solicitors when they are not.
Yeah, sadly, we've had to deal with people who've been the victim of bad solicitors, and that's with people adding people on their EA applications, charging them exorbitant amounts, even charging the dependents who they don't know about exorbitant amounts. And so when the Home Office finds these things, the Home Office is more likely to reject everybody and then try to find out what's happening. So if you find yourself the victim of such a situation, do make sure you make the necessary reports to the regulatory bodies. So you should be dealing with a solicitor that's qualified and experienced, or an OISC member who is qualified and experienced. But again, when you're going to the appeal level, it should be somebody again who is experienced. And OISC members only have a limited amount they can do within the appellate system, so you should go to a qualified barrister or solicitor. And you can get to some barristers through direct access. But if people want to get hold of you, Mr. Amicarelli, Dr. Amicarelli, how do they do that?
You can contact the office on info@obasekisolicitors.com or myself personally on alex@obasekisolicitors.com.
And can I ask, when it comes down to costs and dealing with people that might not even be in the UK, are you able to deal with them? And now we have a lot of elderly people who want to bring in relatives. Are you able to sort of be flexible with how you do your consultations?
Yes, we are very flexible. We always try to find a way to help people in need. So we can do... We regularly do phone consultations,
Zoom.
consultation on Zoom and other platforms, in order to be very open and accessible to everyone.
So, in a few words, if somebody finds themselves missing the deadline, what are the top 3 things you will say to them?
Well, I want to say only one: call us, and get proper help from us.
Okay.
Yeah.
And then
That's number one.
And then at the same time, if they've been refused,
Yes.
don't panic. You can
Don't
appeal.
panic.
Don't panic at all.
Yeah,
you can always appeal.
This
or make a
appeal
fresh
system is
application.
very flexible also. It's a review system, admin review system. So it's not something as formal as a court appeal. So again, we can help you with it if any help is needed with it. Or if we believe that the application you submitted was not that strong, we can help you
faulty
submitting
or
a new
flawed.
application, which can be stronger, and will be we're very happy to help you and your family to move to this lovely country, the United Kingdom.
Oh, well, thank you so much for joining
you,
me this
Jennifer.
evening, Dr. Amicarelli. As I said from the start, your expertise is world renowned at the end of the day. It's not just in the UK that you assist people, or in the UK that you're a member of a professional organisation. So we're very pleased that you spent the time this evening explaining what people can do and what they should do if they find themselves having missed the deadline and wanting to make sure that they themselves settle or want to settle their dependent relatives here in the UK. And before you leave again, since it's not coming home and it's going to Rome, once again, congratulations.
Thank you very much.
Thank you for staying with us this evening on Truth and Justice Television. And next week, we're going to be having a special guest here, and that is going to be the mother of the late Richard Okorege, who's going to be talking to us about her son and the efforts she's making to make sure that everybody is aware of sickle cell illness. Stay blessed, have a great week, and if you can't be good, be careful. Good night.